Hey everyone, good morning, good afternoon, and good evening, and welcome. I'm Paul Kiesel. I'm a trial lawyer, and I founded Speak Up for Justice just because when institutions need to protect themselves when they're under threat, those of us who understand what the justice system is about need to step forward and speak up and out about the challenges we face in this country. So here's where we are. No federal judge has ever been removed from the bench because of a ruling. Not once in 250 years. Right now, that precedent is under direct attack. Judges facing impeachment, not for their corruption, not for criminal conduct, but for their rulings, for doing their job. This forum is nonpartisan. We're not here to relitigate any decisions. We're here because we need to protect the rule of law in this country. I have four of the best folks in the country to help explain what's happening and what it all means. So let me introduce them. To begin with, we have Judge Ungaro, and Judge Ungaro was on the federal district court bench in Southern District of Florida, Miami Division. She was there for nearly 30 years, and she recently she was at the Boy Schiller firm for a bit, and now she has retired and become a true mediator, helping our justice system in a different capacity. And so Judge Ungaro is going to speak with a very unique voice for us. We have Judge Grimm, who's a repeat offender for Speak Up for Justice. We were thrilled to have him in our very first program, and we welcome him back again today. Judge Grimm spent 26 years on the federal district court. He was in the Maryland division. He left the district court and joined Duke Law School, where he served as the director of the Bulch Judicial Institute. He's now currently serving on the advisory committee for Bulch. He's now himself with the JAMS Judicial Arbitration Mediation Services. We have two extraordinary and unique professors who are here today. We have Judge Gephardt. Sorry, Michael, didn't mean to make it judge yet. We have Michael Gephardt. And
Seconded.
is at UNC Chapel Hill. He literally wrote the book on impeachment, and he's going to be talking about that. He's testified before Congress, and he's uniquely qualified to address the subject. On top of that, we have Professor Vladeck, and Professor Vladeck teaches at Georgetown Law School, where he focuses on national security in federal courts. He's relevant today because Judge Professor Vladeck testified before the Senate Judiciary Committee. We're going to hear two other presentations from the committee that Senator Cruz held back in January. Uh, Two other individuals spoke at that. We're going to have clips from their presentation to the committee. It's going to be Will Chamberlain, who I keep thinking Wilt Chamberlain, but he's not a basketball player. Will is a lawyer, and he's going to have a unique view of impeachment in this country. And the other is going to be Professor Luther. And Professor Luther, unfortunately, couldn't make today's program work on his schedule, but we're going to hear from him in terms of his clips. So, look, what's impeachment all about, and why are we here today? And two names have come out in four. One is Judge Boasberg, and the other is Judge Boardman. And we're going to uniquely talk about them in the context of why we're discussing impeachment at all. So Judge James Boasberg, by way of background, uh, is the chief judge of the federal district court in D.C. He issued an order blocking deportation flights under something called the Alien Enemies Act. He found the administration hadn't followed the law. When planes took off, anyway, when he said, keep folks in this country, give them due process, they were still removed from this country. And he then issued an order that was seeking to hold the government in contempt for not following that ruling. And as a result of that, he is now theoretically subject to articles of impeachment. That's Judge Boasberg. Judge Boardman. Judge Boardman is a federal judge in Maryland. She sentenced a man named Nicholas Roski, and he showed up at Justice Kavanaugh's home with a weapon intending to kill him. He, before he went through with the act, dialed 911 himself and said, "Hey, I'm here. I was going to do a terrible thing to turn myself in." And he turned himself in, and he pled guilty. to attempting to assassinate a federal judicial officer. And both his lawyer and the government agreed that the sentencing guidelines would have required the judge, Judge Boardman, to sentence him to 30 years to life in prison. But after hearing the story, she exercised her discretion and she sentenced him to 8 years in prison, not 30, but to 8 years in prison. And as a result of that, she herself is now subject to articles of impeachment for having made that decision. So let me start with Judge Grimm. Judge Grimm, you spent 30 years on the federal bench. And is what's happening now anything that you've ever seen before in your career as a judicial officer?
No, I think that what we're seeing now, these threats of impeachment, two specific judges, Judge Boasberg and Judge Boardman, for specifically based upon disagreements with rulings that they made. And I might say that for Judge Boardman, the government has appealed her sentence. If the Fourth Circuit thinks that she exceeded her discretion, then they'll remand it for new resentencing. And there certainly has been no finding that Judge Boasberg did anything that was any type of misconduct. In fact, he was in a opinion written by the chief judge of the Sixth Circuit, who was reviewing a complaint that the Justice Department filed against him, found that there was no factual basis to support that complaint. So they've done nothing that would constitute misconduct. The only other instance in the history of the United States occurred when Thomas Jefferson was president, and he tried, for political reasons, disagreement with Justice Chase's rulings in favor of the Federalists. He tried to have a politically based impeachment, and six of his own senators had the courage to say no. And so Chase was not impeached when he was tried in the Senate. And that has stood for the proposition that you never impeach a judge in the United States because of disagreement with their rulings. To do so would interfere with judicial independence. It would undermine judicial independence. Without judicial independence, there is no rule of law. Without the rule of law, no one's rights or protections or privileges are safe. And so these threats to try to bring articles of impeachment in the House, which has the ability to do so with a simple majority vote, and then send them to the Senate for a trial, which requires a two-thirds vote. It has never been the case in the history of the United States. And the 15 instances in which articles of impeachment were brought against federal judges, and 8 of them were removed from office, all committed high crimes and misdemeanors such as bribery, such as sexual misconduct, income tax evasion, and very serious misconduct that was absolutely unquestionable that it rendered them unfit to serve. What we're seeing now are attempts to impeach judges for simply taking what they had to do in a case assigned to them, explaining their ruling in a judgment, which is subject to appeal. So the system has a self-correcting aspect. So what
Yeah.
we're seeing now is totally unprecedented.
And Judge Grimm, let me ask you about that. And Judge Ungaro, I'm going to throw this to you for a second. You just said our system has checks and balances to it. And if you disagree with a district court judge's decision, is the answer to impeach them and get rid of the judge, or is there a process in this country to deal with that issue? Judge Ungaro?
Of course, there's a process, as Judge Grimm just said, there's appeal, but there's other things too. There's motions to recuse that can be taken to the chief judge of a district. There is the Judicial Conduct and Disability Act, which allows for complaints to be made against judges, and if there are disputed facts, to allow for committees to be appointed to investigate those facts. There are remedies that the Judicial Council has against rogue judges, if there is such a thing. So there's a whole host of remedies and procedures to address disagreements with judges. But as Judge Grimm said, since 1804, it has been an accepted principle that judges are not subject to impeachment over their rulings. It would, as Judge Grimm said, erode judicial independence, which is essential to the rule of law. And of course, I fear that this is just part of a campaign to erode the rule of law in in the ultimate objective of undermining the electoral process in our upcoming elections.
So I want everyone to understand this isn't a debate happening on cable news or on social media. This is happening in the United States, in our Senate. Individuals are testifying under oath. And the person you're about to hear from isn't fringe voice. Professor Luther prepared over 150 judicial nominees for confirmation hearings. He served as associate counsel to the president. He worked on the Senate Judiciary Committee, and he knows this system from inside and out. And here's what he presented to the Senate committee in January. Let's play that clip.
Thank you for this opportunity to testify about the history of judicial impeachments with an eye towards whether recent conduct by federal judges warrants any action from Congress. Impeachment is an Article I response to misconduct, criminal or non-criminal, necessary to preserve the impartial administration of justice. In Federalist 65, Alexander Hamilton defines impeachable offenses as those done to society itself by the misconduct of public men. Importantly, Hamilton stressed that Congress, as the impeaching body, must be given broad discretion in that determination. When the Constitution was ratified, it didn't define impeachment expressly, but we know from its text that the House holds the power to impeach and the Senate holds the power to convict with a 2/3 vote, that judges hold their offices during good behavior, and that judges shall be removed from office if impeached for high crimes or misdemeanors. Of the thousands of federal judges confirmed by this body and appointed by the president, only 15 have been impeached by the House, with only 8 suffering convictions here. Unfortunately, Jack Smith went fishing and Judge Boasberg handed him a reel. Now, Judge Boasberg will surely dispute this characterization by citing Jack Smith's House Judiciary Committee testimony, where the former special counsel appears to confess that his team did not notify Judge Boasberg that congressional Republicans were subjects of the gag order. Not only is Judge Boasberg seeking to interfere with the executive branch's operations through the contempt proceeding, 2 weeks ago, he ruled that the Trump administration must either facilitate the return of illegal alien gangsters or provide due process hearings for them in Venezuela. These latest intrusions into the coordinate branches call to mind the old adage that a mistake repeated more than once is a choice. Well, you too may have a choice. Judge Boasberg's contempt for the separation of powers fits not only comfortably within the impeachment standards described by Hamilton and the precedents referenced below, he deserves a unique category of his own. The cloak of judicial independence does not shroud a judge from accountability before this body or the public for facilitating violations of the Constitution, federal statutory law, and abusing members of this body, and for pursuing a vengeful contempt expedition into the highest echelon of our national security officials. Judge Boasberg must be held accountable.
Okay, and look, Professor Luther wasn't alone. The next voice you're going to hear is Will Chamberlain, a conservative lawyer and a commentator who focused specifically on Judge Boardman's sentencing of the man we identified earlier who showed up at Justice Kavanaugh's house with a weapon. And here's what Will Chamberlain had to say.
Thank you, Professor Vladeck. Recognize Mr. Chamberlain for your opening statement.
Thank you, Chairman Cruz, Ranking Member Whitehouse, and distinguished members of the subcommittee for the opportunity to testify today. On June 7th, 2022, Nicholas Roski flew from his home in California into Washington Dulles Airport. His suitcase contained a gun, knife, and other equipment that would help him in his plan to assassinate Supreme Court Justice Brett Kavanaugh. After arriving at Dulles, he took a taxi directly to Justice Kavanaugh's home. Only upon noticing the presence of law enforcement did he realize that his plan was futile and give up, calling 911 and allow himself to be detained. Mr. Roski pled guilty without a plea agreement to violating 18 United States Code Section 351C for attempting to assassinate a Supreme Court justice. There was no dispute as to the proper application of the United States sentencing guidelines in this case. DOJ and Mr. Roski's attorneys agreed that the guideline sentencing range for Mr. Roski was 30 years to life. Yet, despite the reprehensible nature of Roski's conduct and the threat it posed to our republic, Judge Deborah Boardman sentenced Nicholas Roski to just 97 months in prison. At sentencing, Judge Boardman described herself as, quote, heartened by how this terrible offense has drawn the Roski family closer and has helped them understand Miss Roski's profound mental health struggles and accept her for who she is. Judge Boardman stated that when she weighed, quote, how much additional incarceration is sufficient but not greater than necessary to punish Miss Roski, that she would, quote, take into consideration the fact that she, a transgender woman, will be sent to a male-only Bureau of Prisons facility. Apparently, Judge Boardman saw her role as family therapist, healing the wounds of the Roski family and protecting Nicholas Roski's claimed gender identity, rather than a federal judge responsible for imposing a just sentence on a would-be assassin. Judge Boardman's case, however, is the rare one where a judicial impeachment would vindicate the integrity of the judiciary and protect judges from improper influence. Judge Boardman's slap on the wrist for Mr. Roski, if left to stand, will only encourage others upset with judicial decisions to try similar tactics.
So, Professor Vladeck, you had the opportunity to appear before that same Senate Judiciary Committee. And the question is there a version where Congress should actually impeach a judge simply for the judge's ruling? Your thoughts on that?
No. Um, so, I mean, let me say it's worth saying that, Mr. Chamberlain throughout his testimony was deliberately misgendering Miss Roski. She identifies as a woman. Her name is Sophie Roski. But putting that aside, the whole point that Judge Grimm already made in the Roski case is that if the government has a problem with the sentence imposed by the district court, its remedy is to appeal. It is appealing that sentence. And, Paul, as for the comments made by Professor Luther, what's really striking and what you wouldn't know from the video, although I covered this in my testimony, is that the two factual charges against Chief Judge Boasberg that try to build a case unrelated to just the substance of his rulings have both been completely repudiated through letters written by the Administrative Office of the U.S. Court, something you guys all know well, a nonpartisan body that actually was in a position to comment about the internal judicial procedures Judge Boasberg followed. And so what we have here is it's not just that these folks are trying to build a case for impeachment based on factual distortions of the record. It's not just that they're trying to build a case for impeachment based on matters that have historically been dealt with through appeal. It's that this hasn't been limited even to the two judges we've been talking about. I mean, as of today, at least, there have been articles of impeachment filed in the House of Representatives against 8 different federal district judges, judges appointed by Republican presidents and Democratic presidents. And Paul, the one thing that those 8 judges have in common, it's not where they went to law school. It's not who appointed them to the bench. It's not what kind of misconduct they're accused of. It's that they all ruled against President Trump. And I think that's really the sort of the dirty little secret in these cases, is that this is an attempt to intimidate judges whose real sin, which is not a sin, is ruling against the executive branch in cases that are properly before them.
That's perfect. In fact, looking Professor Gerhardt, sorry, I'll lead you
No,
again.
I get. I like that. Okay.
Excellent. Chamberlain said that Judge Boasberg deserves a unique category of his own for what he called contempt for the separation of powers. Is there such a thing as contempt for the separation of powers?
Well, there may be such a thing as contempt for separation of powers, but it's not present in this case. So, in the background of all this is something I think we need to call attention to, and that is, I think, both those people who just testified, as well as the president, they're engaged in political theater. So they're critiquing what judges do in terms of interpreting the law and applying the law, but they're not doing it as lawyers. They're doing it as people who are trying to score political points. So, in other words, there's nothing they've said that is constitutionally responsible. I think they've got things flat wrong. Professor Vladeck has already pointed that out. I would just point out 3 other things real quickly that demonstrate, I think, the emptiness really of the arguments being made in favor of impeachment here. The first is, remember, Article 3 judges are vested with life tenure. Now ask yourself a question. Why were they vested or are vested with life tenure? The reason is to guarantee their independence and to protect them against direct political retaliation. What would be an example of direct political retaliation? Trying to impeach them for their decision. Second, we've got really important precedent here. It's been mentioned, the ultimate acquittal of Justice Chase. I would just add to what's been said about Justice Chase's acquittal is that both Chief Justice Rehnquist and Chief Justice Roberts, both appointed by Republican presidents, have said that the Chase precedent controls, and the Chase precedent set really the practice and rule that judges should not be impeached, convicted, and removed for their decisions on the bench. As everybody and as every lawyer understands, judicial decisions are appealable. Ask yourself another question. So what is going to be the harm if these judges get reversed? The answer is almost none. And everything else about the so-called cases against them is hyperbole and just political griping. The third thing I would just mention, and it's just reemphasizing this, we have a process, the appellate process, which is perfectly designed to deal with mistakes and errors that lower court judges make. Keep in mind, we've had that appellate process in place for over 200 years. And one reason why it's in place is because judges understand that they can make mistakes. And so the system is set up so that if a judge makes a mistake in the trial court, it may go to the Court of Appeals and maybe eventually to the Supreme Court, but none of that requires using the impeachment process. There is a whole other reason I think why impeachment is being used here, but I'll get into that a little bit later.
Perfect, Professor. And I guess so that Americans watching this who are not lawyers, who kind of understand the process. The way it works is you have a district court judge, as Judge Grimm and Judge Ungaro were. They're on the front lines. They hear the evidence. They make a decision, or they support a judicial decision from a jury, and then they enter a sentence. In this case, Judge Boardman entered an 8-year sentence for Ms. Roski. If the prosecution disagrees with that, the process is not to impeach her, but to go to the Court of Appeal for the district that she sits in, right?
Right. In fact, just to hammer this point home, what you're hearing from those professors or from those other people that just testified is they want to relitigate the case. Well, there's no impeachment is not designed to relitigate cases that have been heard and resolved, at least in the federal district court. But they want to relitigate the case in a political venue so they can try and score points, not just with the president, but with the president's base.
And
I'm
ultimately,
and
I'm sorry, go ahead.
I was
Professor.
gonna add, and it's I mean, it's worth, I think, also adding the context for when there have been successful judicial impeachments, just to sort of give the other side of the coin here. The impeachment power has been used. I mean, there have been 15 judicial impeachments in American history. I think 8 of those resulted in the removal of the judges. A bunch of the others led those judges to resign. And the cases that we're talking about are cases where you've had judges who were convicted of financial impropriety, judges who were using their contempt power and their coercive powers for personal gain. My favorite, a judge who was continuing to use his federal commission while he was fighting for the Confederate Army during the Civil War. I mean, there's a power here to remove judges when they're engaged in conduct that is so absolutely beneath the dignity of the office, when they're abusing their office. The problem is that the mentality that Professor Gerhardt's mentioning, and that I think really has been pervasive throughout American history, is that judicial independence depends upon the idea that the line between what is and what is not impeachable is whether it's, the substance of the ruling that you're taking issue with, or something that is illicit, unlawful, unethical about the judge's conduct. And that's where I think the recent charges have really tried to blur the line.
In other words, high crimes and misdemeanors were kind of the catchword for what you'd have to have an impeachable offense, not that you made the wrong decision, because if you do, you take it to the Court of Appeal.
Well, because
Oh,
I'm sorry about
may I just add one thing to this?
Yes, two things. Go.
Sorry. So you're exactly right, of course, in what you're saying. What I would just add to this is the fact that with the judges who are being subject to impeachment, it isn't just that their decisions are being relitigated and reheard. I think it's important to point out that they're being politicized. Part of the point of this impeachment effort is to try to politicize the judiciary. For President Trump, everything's about politics, and that would extend to courts. So he's a president interested in diluting the impeachment process because that would make him look better if impeachment just turns out to be a partisan tool. So he wants to turn it into that. But the scope of impeachable offenses, as you just said, high crimes and misdemeanors, treason, bribery, and high crimes and misdemeanors, that was purposely put in the Constitution to narrow the set of claims that could be properly made as a basis for impeachment. And it distinguished the American system from the British system, in which anyone could be impeached for anything. So in our system, it's just a few people are subject to impeachment, and they're not impeachable for everything, but they're impeachable for specific things. And those specific things do not include making mistakes, assuming there were mistakes.
Before we get into President Trump's comments from just last Friday with the Supreme Court ruling, just a couple of bits of education. Typically, it's a 3-judge panel that hears a case on an appeal from a district court, correct?
That's right.
If you don't like what that 3-judge panel is asking for, you can ask for an en banc hearing, correct, for the entire panel to hear it?
Correct.
So you actually have a shot with the 3 judges and a bigger shot with another larger panel. And if they agree all along the line, the next step is a writ to the Supreme Court, right?
Yep.
Right. Okay. And then one other point is when the lifetime tenure appointment was done for federal judges, the life expectancy of a male American, a white male, was 38 years old. Now, there's certainly people who live much longer than that, but the age of life was not what it is today in terms of life expectancies for lifetime appointments. I'm just, as a general point, time has moved on over the past century or so. So I want to play President Trump's clips from his recent press conference so we can have that to discuss with you, Judge Ungaro and Judge Grimm. So let's play the president's clips from his news conference.
The Supreme Court's ruling on tariffs is deeply disappointing, and I'm ashamed of certain members of the court, absolutely ashamed, for not having the courage to do what's right for our country. They're against anything that makes America strong, healthy, and great again. They also are a, frankly, disgrace to our nation, those justices. I think it's an embarrassment to their families, you want to know the truth, the two of them, when in fact they're just being fools and lapdogs for the rhinos and the radical left Democrats, and not that this should have anything at all to do with it. They're very unpatriotic and disloyal to our Constitution.
So we're talking about the United States Supreme Court is being disloyal to the Constitution from the words out of the president's mouth himself. Judge Ungaro, have we ever had, in your lifetime, a similar experience where the president of the United States is calling into question in this way what the Supreme Court has done?
Sadly, no. This is a new event. And I just want to echo what Professor Gerhardt said, which is I also believe this is nothing but political theater, that the president believes that it's in his political best interest to create us versus them scenarios in order to cement his base. But I do think it goes even further than this. As I said earlier, I think it's part of an overall campaign to erode, well, certainly to intimidate the judges that are to the judiciary across the board, but also it's part of a bigger campaign to erode confidence in the rule of law. And of course, we have elections coming up, and that's a big part of what the administration is doing with respect to elections.
So, Judge Ungaro, how does the political theater that's happening on the one hand play into Americans' views of our judicial system?
Well, I think it's eroding respect for the idea is that it should erode respect for the rule of law. And I think it is to some degree effective. When I speak to my former colleagues, they are very concerned about social media, about the proliferation of threats on social media when the administration makes these kinds of comments. It generates more threats. It kind of feeds on itself, and I think it's very dangerous.
Okay, let's play our second clip from the news conference.
I assume to protect other countries. This must have been done to protect those other countries, certainly not the United States of America, which they should be interested in protecting. That's what they're supposed to be protecting. But I am allowed to cut off any and all trade or business with that same country. In other words, I can destroy the trade. I can destroy the country. I'm even allowed to impose a foreign country destroying embargo. I can embargo. I can do anything I want, but I can't charge $1.
So, Judge Grimm, as a former federal judge of over 30 years, is the president wrong when he says he's got unbridled authority to do this?
Well, of course, the president does not have unbridled authority. None of the 3 branches of government have unbridled authority. Article 1 sets out the authority of Congress and says what Congress can do. Article 2 sets out the authority of the president, and Article 3 sets out the authority of the courts. So no president is above the law. The Constitution is the supreme law of the land. It controls all other law, including law passed by Congress. And when there is a dispute about whether Congress has exceeded its constitutional limits, we have limited government, and that applies to Congress, the president, and the courts. If there's a issue about whether Congress has exceeded its power or the president has exceeded his power, the dispute throughout the history of this country since the Marbury versus Madison opinion in the early 1800s is got to go to the courts to decide what the Constitution says. When the Constitution has language that can be interpreted differently by different parties seeking to use it to their achieve policies that they want to achieve. In this particular case, the president was talking about a final decision of the United States Supreme Court in a 6-3 ruling on his tariffs. That decision explained why it was in violation of the Constitution what the president did, and also pointed out other provisions of the Constitution that give him authority to act in certain ways that may not be as quick or as easy as the route that he took with the tariffs. The duty and the allegiance of the United States Supreme Court is to the Constitution of the United States. When the president accuses them of being disloyal to the country, that is a very gross mischaracterization, because their obligation is to the Constitution, which is the DNA of this country on which it is built. And the president took an oath to adhere, to support and defend the Constitution, as do judges, as do members of Congress. And so to impugn the motives in language which is remarkably disrespectful. And let me say this, for someone who seems to be so aggrieved of how the courts are dealing with his policies, issued the rulings they've had when they have ruled against him, have not resorted to these personal attacks or ad hominem attacks on the president. They have treated the president with the dignity that the office deserves. And to see this contempt for them as individuals and this lack of respect to the functioning of a branch of government which is under the Constitution charged with deciding disputes about whether or not a particular branch of government has exceeded its limited power. We have a Constitution that limits the powers of each branch of government. And when that dispute takes place, it's the courts that resolve it and the Supreme Court that has the final word. And to use such disrespectful, demeaning language shows a contempt for this critical function that courts play in keeping the rule of law, which protects every constitutional right, privilege, property right that every American citizen believes is their birthright. And so this is more than just simply political theater. It is intended to intimidate, demean, and to turn the public opinion against the courts, when in fact the public opinion should be that the courts are striving very, very hard to do their very best to do the job that is given to them in the Constitution.
And to be clear, the whole purpose of Speak Up for Justice is to do just what we're doing here, for people to understand the role the courts play in our democracy. And when we cheapen the role of our judicial officers, when we threaten them or we threaten their families, the risk to them personally becomes much more than they ever bargained for, nor as a country we should ever support. So while this must maintain its nonpartisan positioning, the world is being set up in very ideological, blocked ways. And it's important for people to understand that we're having this conversation so you recognize the importance of the guardrail that our judicial system plays in our society, in our constitutional framework. Professor Gerhardt, FDR, Franklin Delano Roosevelt, was very unhappy in 1937 with what the Supreme Court was doing then. Let's talk historically about what happened there.
Yes, with respect to Franklin Delano Roosevelt, he was unhappy much earlier than 1937. In fact, he's the first president in American history to have completed a full term without an appointment to the Supreme Court. That did not please him. And what displeased him further was the court was striking down major components of the New Deal. Roosevelt obviously wanted to try and change things. His court packing plan, which I think was pretty much dead on arrival, was one way he tried to do that. When that failed, he didn't say, "Oh, let's impeach those judges." Instead he waited and got vacancies, and he ultimately appointed the entire court. And he did that all within the boundary separation of powers. Incidentally, he had precedent. His distant cousin, Teddy Roosevelt, wasn't happy with the Supreme Court either. But Teddy Roosevelt did not say, let's impeach the judges or justices. He just put forward and asked that there be put forward different arguments before the court. And then I would also say the same is true for Lincoln and Truman. President Lincoln hated Dred Scott. When it was decided, he decided himself never to mention Dred Scott again, or at least never to mention the court again. And he basically didn't. But the one thing President Lincoln never did was say, oh, let's go after and impeach those judges. Lastly, President Truman, in the famous steel seizure case, not happy with the outcome when his executive order seizing control of the steel mills was struck down. But Truman also didn't say, let's go after the justices, let's impeach and remove them. So we're encountering a sea change here. We're encountering something that is beyond the pale. It's beyond anything that's been attempted before. Another question to think about, and I'll end with this, is why were there no efforts to impeach a justice after Chase based on his or her opinion? Not any effort since then. Only thing that could remotely come close was Justice William O. Douglas, who was subjected to at least scrutiny within the impeachment process. But Douglas was being charged with some of his decisions. That ended up going nowhere. So there is zero precedent, and there's a reason for zero precedent for what the administration is trying to do.
Thank you for that. And look, that was 200 years ago. Professor Vladeck, I'm going to get to you in just a second. So we've been talking about impeachment, but that's not the only front here. The Deputy Attorney General has described this as a war on the federal courts. Stephen Miller has called it a judicial insurrection. And Attorney General Bondi filed a misconduct complaint against Judge Boasberg. When you step back and look at what's been happening altogether, what are we really watching here, Professor?
Yeah, I mean, I think what we're really watching is an effort to try to reduce public faith in the judiciary, to try to undermine the credibility of the federal courts writ large and the lower federal courts in particular, and to try to basically, sort of drag the courts down into the political mud so that if and when we get to a point where the administration is actually engaged in systemic defiance of court orders, it's already set up the narrative that, hey, these judges aren't, independent jurists. They're partisan hacks. And Paul, what's so dangerous about that, and part of why we've been really fortunate historically that presidents of both parties, even when greatly disappointed by the Supreme Court, have resisted these kinds of pushes. The danger is that it works, right? The danger is that, the folks who need to hear how bananas this all is aren't the ones who are joining us today. And they listen to the president and they listen to Stephen Miller and they listen to the deputy attorney general and they say, gosh, these judges really are, partisan activists. Never mind, of course, that so many of them are Republican appointees, not that that should matter. Never mind that you can read their rulings for, yourselves and decide if you're convinced or not. And I think that's why the impeachment piece of this is really just part of this broader attempt to discredit and delegitimize the lower federal courts. Paul, at a time in which the lower federal courts, I would say, have been the institution that have done the most over the last 13 months to stand up for the rule of law, to push back against this executive branch, to enforce legal limits on the president in ways that no one else is, including Congress. And I think those two things are related. I mean, I think the president and his advisors have found the courts to be a real obstacle to a lot of what they've wanted to do. And, if you can't beat them, delegitimize them. And I think that's part of what this is all really circling around.
So here's the question. Thank you for that, Professor. Well, we have some great media input. We've had the New York Times, the Washington Post, the Wall Street Journal been watching what we've been doing here. And they want to know why is it not appropriate for Justice Roberts to get up and say something when the court's attacked? Why, Judge Ungaro, does Chief Judge Roberts not stand up and say, President, why not?
Well, of course, the Chief Justice wants to maintain the court's neutrality. It's part of the legitimacy of the court is that the court doesn't take sides, and so he wishes to appear balanced and neutral in any kind of dispute between the administration and the courts. However, I think we ought to acknowledge Judge Roberts has spoken up when there has been inappropriate political rhetoric against the judges. Actually, he spoke up during the Biden administration, and in one instance, and more recently, he has spoken out about how dangerous the incendiary rhetoric is.
And it's a fair point. And actually, we're going to talk about what we're going to be doing. Our next program is going to be March 19th, and we're going to actually have sitting federal judges addressing this issue, and we'll talk about why there's an opportunity for them to speak on that subject. But before we get there, I want to talk about what's at risk and where do we go from here. So, Professor Vladeck, we keep talking about this as a hypothetical, but Hungary, Poland, Venezuela, Turkey, these were democracies, that independent judiciaries that have been lost. We had a federal judge, Judge Valdivia from Venezuela, who, when he tried to use the force of the Constitution, was threatened with his life and had to flee Venezuela for his own safety. Where do we go from here? What's happening?
Yeah, I mean, I wish that these were hypothetical. I mean, I actually think that we are closer to some of that behavior than I ever thought we'd see in, our American political system. I guess the sort of the 2 points that are worth keeping in mind here is, the federal courts don't enforce their own decisions. They depend upon the political branches. I mean, even the Supreme Court, one of the Supreme Court's oldest rules says that all of its process issues in the name of the president. So, Paul, the question is, why do presidents follow Supreme Court decisions? And the answer is because we have at least and have had a social political culture where defiance of the Supreme Court has been viewed as crossing the Rubicon. And I think it's critical to, keep that attitude at a time, Paul, when we're seeing more defiance of district courts. I mean, we have federal district judges in Minneapolis, in New Jersey, and a couple other parts of the country who are now documenting dozens of cases where their orders are being not followed by ICE. And so I think we really have to understand why, without regard to the merits of these rulings, without regard to which president appointed these judges, defying court orders is not something the federal government gets to do in this country. And there needs to be political ramifications for any such defiance, or else there will be more. And just, one example to illustrate all of this. When President Nixon resigned in August of 1974, he resigned about 18 days after after the Supreme Court ordered him to turn over the last of the Watergate tapes. Why did Nixon turn over the tapes? He didn't have to. The Warren Burger was not about to walk down Pennsylvania Avenue with the U.S. Marshals. He did it because he was convinced that not complying with the Supreme Court would be the end of his political career, that whatever support he had left among Republicans in the Senate would evaporate, guaranteeing his impeachment and removal. That happened anyway. But, that specter, right, that possibility is something that all presidents need to be faced with. And so the way that we stand up for the federal courts at this moment is we push our elected officials, we push members of Congress, we push everybody we can talk to defend the federal courts, right or wrong, because that's what we do. That's why we have them. It's what they're there for.
Understood. And so, Professor Gerhardt, look, we as a constitution have our legislative branch, our executive branch, and our judicial branch. And we talk about a constitutional crisis. And tell us a little, what is a constitutional crisis and how close are we to getting there?
Oh, that's a big question.
And you got
You
two
know,
sets.
yeah. Oh, great. Well, I think there's not a lot of consensus on what a constitutional crisis is, but I would say it arises when the parties um, can't find a solution to the case in the Constitution. Um, but we've had crises in the past where two conflicting views have produced violence and war. Obviously, that was what happened in the aftermath of Dred Scott. Um, so the one thing I also just want to add to this, which I may help fuel a constitutional crisis, is if you go back and listen to what President Trump said or what Stephen Miller said, um, there's one thing clearly absent from everything they said, and that is the rule of law. The rule of law means nothing to them. And I think, therefore, President Trump never recognizes any constraint on his power because he doesn't recognize the rule of law as a constraint. Stephen Miller is not a lawyer, just like the president. He's not a lawyer. But Stephen Miller talks about it's the law of the jungle out there. Well, in courtrooms, it's not the law of the jungle that controls. And whether it's a district court, federal court of appeals, or the Supreme Court, what matters is the legal argumentation and the legal process. And this administration has contempt for both those things.
Well, thank you. That you summarized a whole big question and a good short soundbite for us. So, look, as we begin to draw this incredible session to a close, I want to ask you this: if I'm just an American citizen watching this discussion between us, what should my takeaway be, Judge Grimm? What should I be thinking?
So these programs that are trying to get the backstory about why these matters are so important is vital for us to engage with the American public. The American public ultimately has to have confidence in the judicial system, and the reason why that is that if you don't have the rule of law, if those with power and those with impact and with force can ignore the law or disregard the law, even if they're told that what they want to do is in direct violation of the law, as, for example, a ruling that what they were doing was unconstitutional. If they have the power just to ignore that, then what that means is that when a judge has a case involving the Second Amendment rights of a particular individual or the religious beliefs of another individual or the property rights or the intellectual property rights, or all of the things that guarantee our people, we the people, of the protections that our founders put in place to make this wonderful country of ours the unique experiment that it has been for 250 years, all of those are in jeopardy. If you are an individual, if you are a company that has intellectual property rights and the rule of law doesn't protect them from being stolen by a competitor, then why would you invest the money to come up with these goods and processes that make it beneficial for the rest of the people? And there's not an American out there that doesn't have some protection, personal protection, property protection that the Constitution guarantees. If the Constitution does not limit what any branch of government does, they can violate the Constitution, then no individual American citizen can be sure that if they were in a court case, if you have a judge that is afraid that if they rule the way the law and the facts dictate should come out because of the precedent in the case, they're afraid to do that because they will be impeached for their ruling, or they're afraid about upsetting someone in power who does not care what the law restrictions of their power is, then no American citizen is safe in anything that matters in terms of what it is that makes this a wonderful and great nation. And that is something which is very tragic. And it's it's a shame because most Americans really don't have much contact with the judicial system. They haven't served on a jury, they haven't been sued, they haven't sued anybody, they've just not been involved in the courts. And so they rely upon the information they get from the sources where they tune in to get their information, which is oftentimes social media. And when you have disinformation and purposefully trying to distort what has happened to turn their attention against it so that they do not have faith in the judicial system, why do they want to diminish the faith in the judicial system? Because if the judicial system has been undermined, it cannot function in its essential role to limit in cases where there's a challenge under a case assigned to a judge to the constitutional authority of a government branch. Then it will prevent those limitations from happening, which means that that government branch can take any action that they want to take if they have the power to be able to do it, regardless of what the law says. And I think that it comes down to fundamental fairness. If the little guy is subject to the rule of law, it applies to them. It's got to apply for the powerful. It's got to apply for the rich. It's got to apply for the political. And these kinds of attacks erode that. And that's why helping our fellow citizens, our American fellow citizens who love their country and who love what it stands for, to understand what is at stake when this type of attack takes place, which is unprecedented, contrary to what the underlying facts are, which are distorted in the attacks. It undermines their rights, their privileges, their families, their protections, and that is something that they should be concerned about. And to provide information that allows the American public to understand the true genius of what our founders put in place for this country, which makes it so exceptional, is a very important duty that everyone should have. Not only people who are judges, not only people who have access to these programs, but every single lawyer takes an oath when they become a lawyer to support the Constitution and the canons of legal conduct. The Code of Ethics for Lawyers has a provision in Canon 8 that deals with judicial officers that encourages every single lawyer to continue to preserve judicial independence and the rule of law by speaking out against unjustified attacks against the judiciary.
And Judge, what's interesting is that the oath we take says we'll support the Constitution against all enemies, foreign and domestic. It is both foreign and domestic. What's interesting is the president's oath does not have the word domestic in it. It may at one time have it, but it currently does not have that as a part of it. So, Professor Vladeck, as you're teaching young lawyers looking to embark on their careers, have you seen any shifts yet, or is it still the usual first-year students coming in to learn about the Constitution?
Well, I've got class in 17 minutes, so I'll let you know, and I'll let you know then. But I think, I mean, I think that today's law students, and I'm sure this is Professor Gerhardt's experience as well, are both, I think, deeply motivated by everything they see around them and deeply troubled by everything they see around them, almost regardless of their personal political preferences. That, from an institutional perspective, where we are right now is not especially healthy for anybody. And so I guess, to me, the takeaway for folks, whether they're lawyers or not lawyers, is this is a really object lesson in why institutions sometimes are even more important than the outcomes they produce. And why, we sort of focus on the outcomes at the expense of the institutional relationships to our long-term peril. The federal courts, I think, don't get a lot of attention in contemporary civics education to the extent that's even still a thing, partly because they haven't been a source of controversy for so much of our contemporary, and modern history. But I think part of the focus really should be, we have federal courts for a reason. The last 13 months are pretty powerful evidence of the critical role federal courts can play in standing up to a potential tyranny of the majority. And that's why judicial independence is a value worth fighting for, even if you don't always see on a day-to-day basis how it affects you directly.
And that's a great point. In other words, Judge Ungaro, one of the things my dear friends who are judicial officers say, whenever I'm a judge, I know I'm going to have one party happy and another party unhappy with my ruling. Tell us a little bit about what that means.
It means that the district judges perform their jobs with a great deal of focus and these days with a lot of courage. They are steadfast in their pursuit of justice and in the face of intimidation, in the face of threats. It's not easy, but I think that what recent developments have shown is that the district judges are committed to doing absolutely the best job they possibly can. And actually, my takeaway from this is hopefully that people will appreciate that even under these really difficult circumstances, the district courts are functioning, and they're functioning with integrity and with predictability and reliability and pursuing justice just like they always have and just like they will, assuming all of our institutions hold.
Thank you. And Professor Gerhardt, final thoughts.
Well, gosh, I'll start by saying I sure as heck hope they hold. And I'm sure they will actually. Let me emphasize that. At the risk of a little bit of oversimplification, I think what we're seeing right now is a clash. It's a clash between the rule of law and those forces that want to destroy it. I think it's just that simple. And so if you listen to the administration, they have no interest in the rule of law. Their interest is in domination, shifting blame. And by the way, a lot of the impeachment stuff is also part of shifting attention away from the president's problems onto others. And so I think that's a phenomenon here too. But one thing I think we all agree on is perhaps the most important thing. The rule of law in this country is what protects every single citizen from governmental abuse. If we don't have that protection, then all bets are off. And so respecting the rule of law, which sometimes means respecting a judge who's ruled not the way you would like, all that means is that we believe that we're a country or government of people, a government of laws, not of people, to quote from Abraham Lincoln.
Well, look, I'm very grateful to the four of you and having this dynamic and important dialogue. What's crazy is every week something else is happening, something new is emerging, and I'm hoping that we can, between all of us together, maintain our judicial system, maintain the integrity of our law and our reliability and rule of law. And this is going to be an ongoing dialogue. Next month, March 19th, we're going to have sitting district court judges as a part of our panelists. And the reason why is because the Advisory Committee on Judicial Ethics issued a new rule the other day, Rule 118, that allows sitting judges to speak out, not in a partisan way, but merely as a way to help educate and push back for people to understand the importance of the rule of law. And having the frontline members to address those issues is what we're going to be doing on March 19th. But again, I can't thank you all enough for joining us. You're going to get to class, Professor, and the rest of you get back to work. So thanks, everyone.